The other side of the coin now will be dealt with by Bill Horton. That deals with when a foreign judgment will be enforceable in Ontario. Bill articled and practiced initially with McMillan Binch. Following that, he went out and has been practicing for the last 3 years approximately with Laskin, Jack, and Horton. Later, Laskin, Jack, Horton, and Harris. And now Bill Horton has left that firm and has gone back to McMillan Binch. During that time, he's practiced exclusively in litigation, in a counsel practice, primarily in the commercial litigation area, and has prepared an excellent paper and will now deliver a talk on that subject. I just wonder if at this stage we might say, are there any questions that everybody's got that perhaps at the end of Bill's address we could get Sheila Block back up and ask a few questions. If there are any. If there aren't any, then we'll just move right on to lunch after that. Is there anybody that would want to ask questions that we should stop at the end of the program, at the end of this talk for? Okay, we'll just move right along then. Okay.
Thank you, John. In my paper, which is reproduced in the material you have, I have attempted to identify some of the major issues which arise in connection with the recognition and enforcement of foreign judgments in Ontario, and to outline some of the principles which are applicable. Today, I would like to present the material in my paper in the practical context of 3 types of situations in which a client may seek advice from legal counsel in Ontario. They are as follows. 1, counsel in Ontario is consulted by a plaintiff who wishes to enforce in Ontario a judgment which he has obtained in a foreign jurisdiction. 2, counsel in Ontario is consulted by a defendant who is sued in Ontario upon a judgment which has already been obtained against him in another jurisdiction. And 3, Ontario counsel is consulted by a defendant who is being sued in a foreign jurisdiction and seeks advice as to what, if any, steps he should take with respect to the foreign action. Now, for the purposes of my paper and my presentation today, I will assume that the classic principles of private international law, whereby one Canadian province is a foreign jurisdiction in the same sense as any foreign jurisdiction in relation to another Canadian province. I think that proposition is still good law today, and certainly all of the common law jurisdictions in Canada have been proceeding on that basis. However, I've read and heard Professor Graham's submissions with regard to the Moran and Pyle case, and whether or not that case heralds a new era in Canadian private international law whereby other provinces will be accorded a somewhat better status, and there will be more reciprocity between provinces in Canada than there would otherwise be between a Canadian province and a truly foreign jurisdiction. I must say that I certainly share Professor Graham's sentiments to the effect that that would be a beneficial evolution in our law, but I don't think it is safe to assume in advising clients today that we are operating under that regime. If I may turn to the first situation then, where a client wishes to enforce a foreign judgment in Ontario. I think the first issue which should be addressed in advising the client as to his remedies is whether the foreign judgment is a judgment in rem or a judgment in personam. If the judgment is in rem, for example, a declaration as to the ownership of land or immovable property situated in the foreign jurisdiction, or a declaration as to the status of a person domiciled within the foreign jurisdiction, or as to the status of a corporation created by the laws of the foreign jurisdiction, special considerations apply. In many cases, the question of recognition of a foreign judgment which determines an action in rem will only arise as an ancillary issue to some other dispute between the parties in Ontario. The extent to which the foreign judgment in rem can be relied upon by the plaintiff in Ontario as determinative of that issue in the context of a broader dispute which the plaintiff seeks to litigate in Ontario is problematical. For example, a judgment obtained by the plaintiff declaring his ownership in land in the foreign jurisdiction will be recognized by the Ontario courts if the land is situated in the foreign jurisdiction. However, it has been repeatedly asserted by the courts that such a judgment is a judgment in rem only to the extent that it relates to the ownership of the land per se, and not to the extent that it relates to the rights and obligations of rival claimants to the land, inter se. This is a distinction which I find somewhat metaphysical, and which makes it unclear whether in an action in Ontario, say for an accounting of revenues received from the lands, which the foreign court has adjudged to be owned by the plaintiff would be able to rely on the foreign judgment on the issue of ownership for the purpose of asserting his claim for accounting. Similarly, where a foreign court has adjudged a corporation created by the laws of its jurisdiction to be insolvent and has appointed a liquidator, the order of the foreign court may be recognized in Ontario for some purposes, but not for others. The foreign liquidation order may be recognized in Ontario as a determination of the fact of solvency or insolvency. It will usually also be recognized for the purpose of vesting chattels, securities, and other movable property located in Ontario in the liquidator, although an application for a vesting order might have to be made in Ontario. However, in order for the liquidator to assert his status with respect to real property located in Ontario, the liquidator will probably be unable to rely on the foreign liquidation order, but will have to institute fresh proceedings in Ontario to establish his status. Obviously, if the foreign court is held by our own courts to have acted without jurisdiction in issuing a judgment in rem, no recognition whatsoever will be extended to the foreign judgment. Now, turning to a judgment in personam, which is the more common form of judgment, there's a very important limitation here. The client will be unable to enforce any foreign judgment in personam in Ontario unless the judgment is for a debt or liquidated sum of money. No other foreign judgments in personam, by our rules, are recognizable or enforceable here. If this qualification is met, the client will have a number of alternatives as to how to proceed. The first alternative, which might be considered, if the foreign judgment was obtained in another Canadian province or territory other than Quebec, is the registration of the judgment under the Reciprocal Enforcement of Judgments Act. All of the other common law jurisdictions in Canada are now reciprocating states within the meaning of that act. However, contrary to popular belief, the Reciprocal Enforcement of Judgment Act does not preclude the foreign judgment debtor from raising any or all of the defenses which he would have been able to raise if the plaintiff had just sued in Ontario in the normal course. On the contrary, it's arguable that additional defenses are available to registration of a foreign judgment obtained in a reciprocating state than would be available in a normal action brought by the creditor on that judgment in Ontario. For example, under the provisions of Section 3 of the Act, it would seem that a contractual submission to the jurisdiction of the reciprocating state will not be a sufficient basis for sustaining the registrability of the judgment in Ontario if the judgment debtor did not carry on business or ordinarily reside within the jurisdiction of the foreign court. It's also arguable on the wording of Section 3 of the Act that a technical defect in service of the process on the defendant in the foreign court will constitute a defense to registration, even though the defendant was ordinarily resident or carrying on business within the jurisdiction of the reciprocating state or agreed to submit to the jurisdiction. These defenses to registration would not be available in those circumstances if the plaintiff simply sued on the foreign judgment in Ontario in the normal course. In addition, Section 3 of the Act specifically preserves as a defense to registration all of the defenses which would have been available in a normal action on the foreign judgment. However, where none of these additional defenses to registration which might arise under Section 3 of the Act are likely to arise in your particular case, the Reciprocal Enforcement of Judgments Act does provide a simple and summary procedure whereby the foreign judgment can be registered in Ontario. Any defenses to registration can be dealt with on a summary application, and if you succeed in registering and holding on to registration, then that judgment will be enforced in Ontario just as if it were an Ontario judgment. A second alternative, which a plaintiff who has obtained a foreign judgment in personam may wish to consider, is the bringing of an action in Ontario on the foreign judgment. Assuming that the judgment is for a debt or definite sum of money, which of course it has to be, the claim upon the foreign judgment can be specially endorsed pursuant to Rule 33. The claim would be brought under Rule 33G as a claim upon a judgment. Now, this may not appear to be very surprising or contentious, since the clear wording of Rule 33 contemplates a claim upon a judgment. But there is something of a paradox here. In theory, foreign judgments are not actually recognized in Ontario as judgments at all, but they're recognized as simple contract debts. At common law, a foreign judgment given by a court of competent jurisdiction was considered to give rise to a moral obligation on the defendant to pay the sum awarded, which was enforceable by way of an action in a sumpsit, which was a form of action for a simple contract debt. Thus, for example, the courts have consistently held that the provisions of the Limitations Act, which apply to judgments, are not applicable to foreign judgments. Rather, the 6-year limitation period, which applies to simple contract debts, is the relevant limitation period. Of course, under Rule 33, a simple contract debt can only be the subject matter of a specially endorsed writ if the contract is for goods sold and delivered or work done and services rendered. Nevertheless, the availability of a specially endorsed writ for a claim upon a foreign judgment does now appear to be well established. If a specially endorsed writ is employed, the plaintiff's endorsement may be confined to a recital of the particulars of the judgment itself. No recitals as to the competence of the foreign court to adjudicate upon the claim or recitals as to service upon the defendant of the process in the original action are necessary. In drafting the endorsement, the plaintiff may simply rely on the presumption that the foreign judgment was given by a court of competent jurisdiction and is valid and binding in accordance with its terms. Now, that's a rebuttable presumption, but the onus will be on the defendant in his affidavit of merits to raise any issues as to the jurisdiction of the foreign court with respect to the subject matter of the claim or with respect to his own person. In addition, the defendant may also raise in his affidavit of merits other affirmative defenses which are available to an action on a foreign judgment, such as fraud, or the judgment is contrary to public policy, or satisfaction of the foreign judgment. However, the defendant cannot successfully raise any defenses going to the merits of the claim which was adjudicated by the foreign court. Where an action is brought on a foreign judgment, the issue is the enforceability of the judgment itself and not whether the foreign court came to a correct conclusion of law or fact. A further alternative, which the client in this situation would have, is to sue on the foreign judgment and, in the alternative, to sue on the original cause of action. This option arises because of the anomalous non-merger rule with respect to foreign judgments. Whereas a judgment adverse to the plaintiff suing on the same cause of action in Ontario will be a bar to the plaintiff suing in Ontario. In other words, he's been unsuccessful once on that same cause of action. The same is not true if the plaintiff succeeded in the foreign judgment, in obtaining a foreign judgment. In that case, his rights to the original cause of action are held not to merge in the foreign judgment, and he has an election as to whether or not to sue in Ontario on the foreign judgment or on the original cause of action, or both. There are a number of obvious advantages to a plaintiff suing on the foreign judgment and alternatively on the original cause of action. For one thing, given the technical complexity of the rules relating to the recognition and enforcement of foreign judgments, it is possible that the plaintiff's claim on the foreign judgment may founder on some technical rule. Now, if that occurs at an advanced stage of the action or on appeal, the adverse impact on the plaintiff in terms of costs and delay could be serious. But if he claims in the alternative, he preserves his right to recover on either basis until judgment is rendered. If he is held to be entitled to recover on both branches of the action, he will have his election as to the basis upon which he would like to have judgment. This creates certain other advantages in favor of the plaintiff, since the date of currency conversion or the assessment of damages may differ as between his claim on the foreign judgment itself and his claim on the original cause of action, which is adjudicated upon by the Ontario courts. This would give the plaintiff the option of choosing the most favorable basis on which to take judgment. However, there are also obvious disadvantages to suing in the alternative. First, the time and costs involved in the lawsuit will almost certainly be increased because by suing on the original cause of action, of course, all of the merits of the claim will be open in the ordinary course. Second, there is the tactical disadvantage that the right to recover on the foreign judgment alone may be colored and seriously prejudiced if the court holds against the plaintiff with respect to his claim on the original cause of action. Now, I'd like to turn to the second situation. When consulted by a client who is sued in Ontario on a judgment which has already been obtained against him in another jurisdiction, the issues might usefully be considered in the following order. First, is the foreign process upon which the Ontario action is based truly a judgment in the sense that it is issued by a court or judicial body akin to a court in the foreign jurisdiction? A foreign arbitration award, for example, is not a judgment for our purposes. But if the foreign arbitration award has been registered with a foreign court and has taken effect and is enforceable as a judgment of the foreign court, it may then form the basis for an action in Ontario. Second, is the foreign judgment final and conclusive in the jurisdiction in which it was given? In this context, finality means that the defendant does not have the right to have the proceedings reopened by the very court which granted the judgment. The fact that by the rules of the foreign court the defendant is permitted to bring an application to, say, set aside a default judgment in the discretion of the court will not alter the final nature of the judgment, because the defendant is not proceeding as of right. He's proceeding to ask the court to exercise a discretion in his favor. Similarly, the existence of a right of appeal to another court, and even the fact that an appeal may be pending in the foreign courts, does not alter the final nature of the order unless the foreign court has ordered a stay of execution pending the appeal. Obviously, it is prudent for counsel to obtain competent, independent legal advice in the foreign jurisdiction as to these matters. The third question, of course, is whether or not, if it's an action in personam, it is for a debt or liquidated sum of money. The fourth question is whether or not the judgment was given by a court of competent jurisdiction. Here, two issues are to be addressed. A, did the foreign court have jurisdiction to enter the action under its own domestic laws? And B, will our courts recognize the foreign court as having had jurisdiction with respect to the parties in the international sense of the word? Once again, with respect to the domestic competence of the foreign court, there's really no substitute for an informed and competent legal opinion or information in the foreign jurisdiction involved. With respect to jurisdiction in the international sense, I think the issues can be boiled down to two. A, did the foreign court have or acquire jurisdiction over the defendant as a result of his residence or even presence in that jurisdiction when the action began or when he was served with the process of the court? And B, did the defendant, by agreement or by his conduct, attorn or submit to the jurisdiction of the foreign court? The issue of residence or physical presence will turn on a number of familiar sorts of criteria in addressing those kinds of issues. Temporary presence or temporary residence has been held to be sufficient, provided the defendant was not tricked into coming into the jurisdiction and so on. In the case of a corporation, the question of presence or residence will be determined by considering whether the corporation was carrying on business in the foreign jurisdiction at the relevant time. The attornment of the defendant to the foreign jurisdiction may occur as a result of the defendant's having contractually submitted himself to the foreign jurisdiction with regard to the dispute, or by the defendant having himself instituted proceedings in the foreign jurisdiction, or by the defendant having voluntarily appeared in the foreign action. Finally, in advising a defendant sued in Ontario upon a foreign judgment, consideration should be given to a number of affirmative defenses which are available to such an action. These defenses include, and I'm just going to list them for you, that the foreign court was induced by fraud to exercise jurisdiction with respect to the action, or second, that the proceedings in the foreign court were contrary to natural justice, or that the foreign judgment amounts to an enforcement of the penal or revenue laws of the foreign jurisdiction as opposed to the enforcement of a private right, that the judgment or claim upon which it is based offends the public policy of our own courts, or finally, that the defendant has satisfied the foreign judgment. It should be said that many of these defenses are restricted in their practical application. For example, it has been repeatedly held that the defense of fraud relates only to fraud going to the jurisdiction of the foreign court and not fraud going to the merits of the action. Even in principle, this distinction is hard to accept, since it would appear to grant a greater immunity to foreign judgments than to domestic judgments with respect to setting them aside for fraud. Also, the utility of a defense based on fraud is questionable, since the absence of jurisdiction of the foreign court by its own laws is a complete defense to the action on the foreign judgment, regardless of whether or not the foreign court was fraudulently induced into believing that it had jurisdiction. As I point out in my paper, the defense based on an argument of natural justice is rather infrequently accepted by our courts on the basis of a somewhat relativistic view of natural justice. The final situation which I would like to cover in these brief remarks is the situation in which Ontario counsel is consulted by a defendant in a foreign action who seeks advice as to what, if any, steps he should take with respect to the foreign action. An obvious preliminary consideration is whether the defendant has significant assets or commercial interests in the foreign jurisdiction in which he has been sued. If he does, a default judgment in the foreign jurisdiction may be unthinkable, and the client's interests may clearly lie in defending the foreign action to the fullest. This may also be true where an adverse judgment by the foreign court may seriously impair the individual's reputation in other jurisdictions. The difficulty arises where the defendant has no significant assets or commercial interests in the foreign jurisdiction in which he is sued. Usually, apart from any other consideration, the cost and inconvenience of defending that action in the foreign jurisdiction will suggest that the action should not be defended unless the defendant's assets or interest in some other jurisdiction are going to be adversely affected by a judgment in the jurisdiction in which he's being sued. Usually, the concern will be the recognition and enforceability of any foreign judgment in other jurisdictions in which the defendant has assets or commercial interests. Here, a cautionary note is necessary. If the defendant has assets in jurisdictions other than Ontario, the recognition and enforcement of the foreign judgment in those other jurisdictions will be governed by the laws of those other jurisdictions. So Ontario Counsel, unless he or she is particularly qualified in the law of other relevant jurisdictions in which the defendant has assets, should really confine his opinion to the effect in Ontario of the defendant taking any steps or failing to take any steps with regard to the foreign action, and seek counsel in other relevant jurisdictions as to the effect of any steps in those jurisdictions. Consideration should, of course, be given to the possibility that the foreign court may be held in Ontario to have jurisdiction in the international sense with respect to the defendant, regardless of whether or not he appears to the action or takes any steps to defend the action on its merits. For example, has the defendant contractually adhered to the jurisdiction? Was the defendant served with the process of the foreign court in the foreign jurisdiction? Where such clear bases for jurisdiction in the international sense exist in the foreign court, the defendant should be advised to defend the foreign action to the best of his ability and means, since even a default judgment in those circumstances would be recognized in Ontario as conclusive on the merits. If, however, it is determined that the foreign court would not be held in Ontario to have jurisdiction in the international sense, unless the defendant were to voluntarily appear to the action, the difficulties in advising the defendant become enormous. Clearly, if the defendant enters a full defense to the foreign action on the merits, he will be held to have adhered or submitted to the foreign jurisdiction. But can the defendant safely make representations to the foreign court that it does not have or ought not to exercise jurisdiction with respect to the matter under its own laws without being held to have adhered or submitted to that jurisdiction? The notorious decision of the English Court of Appeal in Henry and Giapresco was to the effect that a defendant will be held to have adhered to the jurisdiction of a foreign court if he appears before the foreign court, in that case the foreign court was an Alberta court, to attempt to persuade the foreign court to exercise its discretion to decline jurisdiction with respect to the matter, and if he's unsuccessful in that attempt, he'll be held to have submitted to the foreign jurisdiction. The English Court of Appeal proceeded on the assumption that the procedure followed by the defendant before the Alberta court was analogous to a conditional appearance under English rules of practice. Henry and Giapresco was followed by our own High Court in the McCain case, and the details of these cases are in the material. But on appeal, although the Ontario Court of Appeal dismissed the appeal, it expressly declined to say whether the Giapresco decision should be followed in Ontario. In my paper, I have expressed some thoughts as to the limits of the decision in Henry and Giapresco. For the moment, I will confine myself to saying that the English Court of Appeal expressly disavowed the principle that an appearance to protest jurisdiction and nothing more would amount to an adherment to the jurisdiction. It seems that the analogy to the English procedure relating to conditional appearances, the fact that the defendant in Henry and Giopresco sought to have the Alberta court exercise a discretion in declining jurisdiction as opposed to just making a finding as to the jurisdictional facts, and the fact that the defendant before the Alberta court sought to take positive advantage of Alberta law, namely a provision of the Alberta Arbitration Act that an action would be stayed if the agreement contained a Scott Avery type arbitration clause. And it seems that these factors were really determinative in the Henry and Giopresco decision. However, it's very difficult to apply the decision in Henry and Giopresco uniformly to all possible foreign proceedings, given the great variety of procedures available in various forums for challenging the jurisdiction of the court. In Ontario, a challenge to jurisdiction will usually be made by a defendant served ex juris before any appearance or conditional appearance is filed. Now, in some jurisdictions, the filing of an appearance is a prerequisite to challenging jurisdiction. In still other jurisdictions, and Ontario may become one of these if the recommendations of the Civil Procedure Revision Committee are accepted, no provision is made for the filing of any form of appearance. Surely a more sensible line to draw is whether or not the defendant has merely made submissions as to the jurisdiction of the foreign court, in which case he should be held not to have a torn, or whether he has actually submitted some of the merits of his position to the foreign court. Nevertheless, it seems to me that the safest course is to advise the client in the circumstances that he should do nothing in relation to a foreign action if it is fairly clear that the foreign court would not be held to have jurisdiction in the international sense in any relevant other jurisdiction, in the absence of a voluntary appearance. However, if there is some doubt as to whether the foreign court would be regarded as having jurisdiction in the international sense, or if there are other good reasons for attempting to prevent the foreign action from proceeding, the defendant should initially limit his representations to the foreign court to solely protesting the jurisdiction. And I doubt that that would even be caught by Henry and Giopresco. The risk of such an appearance being held to constitute an attornment to the foreign jurisdiction will be minimized to the extent that the defendant does not attempt to base his challenge to jurisdiction upon discretionary grounds, such as, say, forum conveniens, does not seek to take positive advantage of laws of the foreign state, such as the Arbitration Act, and does not enter a conditional appearance whereby he basically submits the determination of that issue to the court and says, I'll be bound by it. Of course, this could be a counsel of perfection. In the circumstances of a particular case, the taking of such steps before the foreign court may be unavoidable or even advisable, but where such steps are taken, they should be taken with a full consciousness on the part of Ontario counsel and on the part of his client as to the risks involved. Thank you.